Good afternoon, everyone. Welcome to today's webinar brought to you by Lawyer Cover with special guests from Net Diligence and Nelson, Levine, DeLuca, and Horst. We're going to be talking today about cyber risk management for lawyers and the growing legal liability and claims that stem from that. Before we get started, I'd like to take just a moment to explain the technology that we're using today. You should see on the right-hand side of your screen a control panel. If you will click the arrow in the upper left-hand corner of that control panel, you can close or open the control panel. You can also use the control panel to submit a question via chat at any time during today's webinar. Just type your question into the chat box and click send, and we'll queue your questions up and we'll answer as many as we have time for at the end of today's session. And now I'd like to turn the floor over to John Mullen, who will take the presentation from here.
Thanks so much, Mike. We're going to start today by just sort of setting up some basic background on what's going on with data security and in the world of data and why it's even important, frankly. Law firms in particular have a great deal of data that they've been collecting for years and years and years. And, you know, being a partner in a law firm, I know that can be a challenge to protect it. But if you take a look at the screen and ask yourself, can you answer any of these questions about your firm and what you're collecting? It's somewhat of an e-discovery analysis, but do you really know what you have? Where is it? How well is it protected? Who can get to it? When do you get rid of it? It's all those kinds of questions that we've heard in the world of e-discovery that are now causing you to have additional duties that frankly did not exist at the turn of the millennia. In 2000, there were no data laws to speak of. Now there are 46 state laws that you need to comply with. There are federal laws. There are laws dealing with separate and apart from the laws. There are PCI, which is the payment card industry laws. There's a lot of different things out there that didn't exist before. Those laws, as we'll talk about, created a lot of duties, and from those duties come a fair amount of first and third party exposures in terms of what happens to your firm if and when you have a data breach. Mark will talk about the likelihood of that happening to you. And the last thing I will do before I turn it over to Mark to get into some of the more technical aspects is to suggest to you that, you know, having been in this business for about 10 years, here's what I do know. It's probably not covered under your professional liability policies. It's not covered under your general liability policies, E&O, those kinds of policies. This is a whole new world of data. It's not property. It's not personal injury. It's an exposure that firms have that they're not necessarily aware of. So with that, I'll turn it over to Mark, who can talk a little bit more about some of the technical aspects.
Hi, everybody. So my company, we assess about 300 businesses a year, all sizes, all sectors, some in the legal community. And one thing they all have in common, about 90% of them have had an incident, if not this year, the year before that. The frequency is that high. But what we're seeing with some of our customers who we assess, and we assess them, just so you know, generally so they can qualify for cyber risk insurance coverage, because we work for about 30 insurance companies out there who do that. But what a lot of the risk managers or the CFO or treasurer, whoever buys your insurance, the one thing they're trying to get their arms around is what's the reasonable chance of this happening, and do our current safeguards measure up with industry standards? You know, what threats should we be worried about? So what I want to give you in the next few slides is some of the things my guys see every day in and day out. What's impacting a lot of businesses out there is, yes, there is malicious threats. You can't go a day without seeing some online news report about some major company breach. There is stealth hackers out there, but very often, I would say almost more common, it's the non-malicious events impacting companies, causing them legal liability, and federal and state regulators to come after them, especially attorney generals. It's employee mistakes. I cannot tell you how many lost laptops there are with all your customers' information in that lost laptop. It's left somewhere, and now somebody has access to that private data. It's business partners upstream and downstream from you who are in the care, custody, and control of your data. They may be managing your systems, or they're just working with your firm in some way. Some of the things really compounding this risk is just the massive amount of outsourcing we're seeing. Very often you may have part-time IT folks running your network. You may be putting your data into a cloud. We're seeing more trends there. But when that provider goes down, or if that provider has a breach, your information's touched, and the victims are going to be looking to you for remedy. The other thing there, Mark, is when you have a breach in the cloud environment,
or frankly any environment, the fact that you're using a vendor isn't going to get you off the hook. The duties flow to you because you're the ones who have the data in the first place. If you have indemnity pieces in those contracts, that's great. You might be able to enforce them, but it's not going to save you the trouble of doing what you have to do under the laws.
Right. That's a good point, John. And then the final 2 points on this slide is, where is your data? It's one of the questions we ask when we come in and assess a company is, can you tell me what kind of data you collect and where is it? Do you have an inventory? What systems? Does it reside in your network, your walls, or outside of your walls? Many times you get deer in the headlights type of look there from IT guys. They lose control of it. There's a little slogan. It's a little bit of a cliche in our industry. It's not if, but when, but it's pretty accurate.
Ask yourself, the people on the phone, if you have half a clue what's on your own hard drive on your own laptop.
Yep. So a lot of our customers want to know, again, how real is this? We try to give them some anecdotal evidence of what other industry experts are seeing. You think of Verizon as a cell phone company. They are, but they have a massive security and forensic group. And every year they do a nice computer crime study. Well, they're showing that 60% of events, data breach incidents, aren't detected by the companies themselves or detected by third parties. And there's a number of reasons for that I'll go into, but it's really bad because that's one of the first things the attorney generals will come back with you in your enforcement actions, or the plaintiff lawyers love to highlight the fact that you didn't actually detect the breach of your own network, therefore you failed to give timely notification to the victims. 96% of the events they investigated could have been avoided through simple controls. I don't really agree with that. That's easier said than done, and I'll go into why. And then we'll go into Larry Poneman of Poneman Institute, who's a privacy guru. He's showing the trend going upwards for a number of data breach events, a number of businesses incurring them each year. The cost per event tends to go up. And then my company, Net Diligence, actually does an annual claim study with the insurance industry. And our average data breach event for a claim actually paid is coming in at about $2.5 million. But the crisis services alone, which we'll get into later, which is, for example, the cost to investigate the event and notify the victims, is $800,000 alone. Some of the top perils facing firms, it can be your IT operations are decentralized. Within your firm, you might have multiple locations throughout the country. Those IT folks running those servers in those different cities could be doing different things. They're not uniform, and that leads to exposure. Hacking. We do still see hacking through something called SQL injection. SQL, not to get too complex here or technical, SQL is just a very common database that the bad guys are able to exploit. I mentioned earlier lost laptops. That's very common. We also see a lot of lost backup tapes, where we see a client, a firm may ship your lost backup, your existing backup tapes to, for example, Iron Mountain. Somewhere along the way it gets lost, and then there's finger pointing between the shipper, your firm, and Iron Mountain as to who lost it and who's at fault. We do see staff mistakes. I think that's more than 50% of the time. Those lead to data leaks of private information, and it's not always just data, it's paper records. We see a lot of paper records being improperly disposed of, and the attorney generals will come after you for that. And then final point here is business partner mishaps. I cannot tell you how many times we see client being sued or something happen to them, and if you actually look at the fine print, some business partner of theirs actually had the mishap.
It's funny, you see a lot of headlines about hacking, and one of the things I hear from smaller companies is, we're not important enough to get hacked. No one's going to target us. That may be true, but if you look at what Mark just put up in front of you, you'll recognize that well over half of the overall breaches don't come from hacks. They come from employee mistakes. They come from vendor mistakes. So you don't have to be a big, juicy target to have one of these major breaches.
Yeah. And this is just a slide showing a few recent incidents that were in the press, just impacting some law firms for some breach-related incidents. Why is this happening? Well, most firms do collect and store private information on people. Many times you're collecting more data than what's actually needed for the case, and very often we see firms keeping data too long. There's no actual records retention program. You may, for example, have 30 or 40 years of client records that were never deleted or never destroyed, and now the bad guy got into those records, your exposure just went up fourfold. Websites that face the internet we find them to be very porous, and it's a challenge for an IT person, especially if he's a part-timer or he's shared, to keep up with the daily hardening and patching of servers. Intrusion detection, we find that weak across the board. That's intrusion detection. IDS is simply the ability to detect the breach of your own network, and I'll talk about why that is in a couple slides. And then finally, bad guys, when there is a breach, we see they just exploit human weaknesses, human error. the final bullet point there, guessable access. The number one password in this day and age, due to a recent study, is 123456. I want to go into 4 common weak spots that we see across the board, not just unique to law firms, but to any company, large and small. Intrusion detection, the failure to detect a breach of their own network. Most companies can't do it. Problem is, intrusion detection systems aren't perfect to begin with. They produce a lot of false positives, and that tends to drive your IT guys batty. So they tune it down to get less false positives, and that's when the bad guys slip in. But if you don't detect the breach of your network, that's something that the lawyers and enforcement watchdogs tend to come after you for. Patch management, all systems need care and maintenance, usually on a daily basis to keep the bad guys out. Well, some experts out there show you need to spend, on average, 1 or 2 hours a day just managing your patches on your server farm. We find very few firms or companies, for that matter, to have the time and budget and people to do that. So bad guys can take advantage of that.
One of the problems with patch management is you're always pushing your IT people to give you that report or give you this report, and they don't get around to this. And another issue that comes up with patch management is that it takes time. And so it might take 2 hours just to do one patch, but if you don't do the patch, the hacker community knows that patch needs to be there. You're going to be exploited at some point.
Yep, and on that point that John just made, this is, say you have a Microsoft environment, they may say this patch is out, this is Patch Tuesday, they come at you with 60 patches. Well, you just can't put them on your servers willy-nilly. You actually have to test them in a non-production environment, because they may keep out the bad guys, but they can also break your systems. So your IT folks typically will test them before they deploy them live. Well, that could take months, and that's, again, the time lag that the bad guys take advantage of. Encryption. Very few companies, and especially very few law firms, will actually encrypt private customer data at rest being in the database layer. You may be encrypting backup tapes or wireless communications or emails, but actually ask your IT guys, is our databases encrypted?
Is that hard to do?
It's not hard to do, but there is some complexities to it that many companies try to avoid doing it. It can degrade system performance. There's licensing cost to it. So for all those reasons, we see a lot of companies try to avoid actually encrypting the database. Missing data loss prevention. DLP is a relatively newer technology, but the beauty of it is it prevents those innocent data leaks I talked about. It traverses it won't allow certain private information to go outside your network without explicitly requiring it to. But again, it costs time, money, and people to manage that thing. What can a risk manager do? And your law firm may not have a traditional risk manager who it's a full-time job. It could be a treasurer or CFO. But really, they need to understand that IT security, data security is never 100%. It's really going to happen someday. The key is, are you able to control the severity of it? You've got to look at it through the prism of traditional risk management, we believe. You can eliminate certain risks. You can mitigate some risks. You're going to have to accept some risk. And then finally, if you want, you can cede residual risk through privacy insurance.
For what it's worth, on the last point there, I spend 100% of my time as a lawyer handling data breaches for companies that call me largely freaking out because they've had this thing happen, they know what to do. The very first question I ask them is, are you insured? And I say that because the minute I hear a yes, I breathe a sigh of relief for them, because I know it's going to get handled right.
Yep. And if you wanted to study the risks in your own company, you can go through a cyber risk assessment. And if you want to undertake that process, we recommend you don't just have someone who can test the firewalls. It's got to be a wide-angle approach. You want to look at the people, the processes, and technology together. It often starts with the people. We just assessed a large retailer just the other week, and it was great talking to the woman who's in charge of IT security there, because one, she was in her job for like 20 years, which is unheard of in IT, let alone security anymore. Two, she loved her job. She could not stop complimenting them on allowing her to go for continuing education, certification. So the fact that she loved her job, it was cool talking to her, because they turned out to be a great risk, mainly because of her attitude and the fact that she displayed daily vigilance in doing her job. Just a quick example of what a cyber risk assessment may look like, especially if you're using this in the insurance industry to get cyber liability insurance. This is something very common that the whole industry sees. It can start with a self-assessment. Your IT guys simply fill this out and measures them to an international standard called ISO 27002. We then can do phone call interviews to flush out any of the red flag or gray areas. We review some key policies like data protection and privacy policies, and then we'll do something called a network vulnerability scan test, which simply is analogous to going up and wiggling your doorknob to see if it can open up. It's there to probe if your systems can deflect some 6,000 known vulnerabilities that impact businesses every day. And then you wrap that in a report that is built for not the CIO, but for the risk manager in lay person language.
So if a firm asks you why bother, why bother doing the assessment?
I mean, the main thing is that the guy who bears the risks in the company and getting insurance, they have to have a sense of, do our practices reasonable? Do we have enough controls in place to mitigate the risk? It doesn't mean you're going to knock everything out, but it just has to show some level of reasonableness. And if you do have an event down the road, that report can actually help you in the defense of that claim, as John can use that report then in that case. The assessment summary screen that I want to go over is really, what is it? It's just a process that allows your firm to reaffirm and document that reasonable practice is in place. You're showing good faith compliance of certain regulations, such as state laws, and there's lessons learned from past incidents. Usually what comes out of these things is, yeah, we had this event happen last year. It's almost a confession for some of the IT guys. They said, this thing happened, but here's how we corrected it, and we think we're now battle ready going forward. Underwriters, insurance companies love to hear that, because in many ways that makes you a better risk in their eyes, because they know you've been through this, you lived it, and now you're ready for the next one, as opposed to a company who, A, is either lying about this or they just never been through it, so they're more of an unknown entity at that point. The process should be collaborative. This is not come in, we own you for a month, like a traditional Big Four auditor might do for a SAS 70. This is a collaborative risk management process. It's there to educate. And many times we're peer reviewing things that your IT guys might have already been through, and we just fill in the gaps and make it more of a streamlined, efficient assessment review. I'm not going to read through these, but this is some example questions that we'll leave you with, just to start the discussion with your own internal IT folks as, do we even have risk here? These are just some questions that we're going to leave you with. With that, I'm turning it over to John.
Thanks, Mark. You can feel free to interrupt me since I interrupted you the whole way through. Listen, there's a couple points I wanted to talk about that Mark touched on, and I want to reemphasize. One is, there are malicious actors out there who may choose to hack or go after your firm, but there are also just dumb malicious people. And what do I mean by that? I mean, it's the guy who walks down the street and throws a brick through your window when you're closed and steals 3 hard drives, who goes out and sells them for $50 each. Well, what's on those hard drives may not have been intended to be put in play in terms of PII, that's personal health information or personally identifiable information, but it triggers all the same laws. So I see a fair amount of, broken into cars and office fronts that get broken into that, obviously the goal was not to pilfer that type of information, but the reality is you've just triggered what's on the board in front of you here, which is 46 different state laws and more coming that deal with the concept of, now that you have the data, what do you do when the data is compromised? Now, as lawyers on the phone, you'll also appreciate that those statutes are all different from each other. They are somewhat vaguely written. There is virtually no case law explaining what any of them mean. So when you look at these things, and it's difficult sometimes to even define what is or isn't personally identifiable information. For instance, in California, they have a statute, and not that long ago, last fall, there was a decision on the Song-Beverly Act which said zip codes are now tied into personally identifiable information. So now in California, theoretically anyway, it's not legal to gather my name with my zip code. Now, I've gone to the gas pump in the last 6 months in other states where they ask me for my zip code when I use my credit card. So obviously there's some disparate impacts of all this, but trust me when I tell you the plaintiffs bar is looking at all that stuff, and they're going to use it against people who they sue.
And in California, John, there's actually statutory damages for that, which turned into class actions overnight.
That's right. It's $1,000 a pop for one of the California statutes. Statutory damages, they don't even need to get into the analysis of, is future fear of identity harm, is that really damages, giving you standing or not? And we'll get to that a little bit later. The other thing to think about on this slide is that it's really not where you do business. It's where the people in your database live. So if you have an office we're sitting outside of Philadelphia, or New York or Baltimore or wherever, you may be thinking you have Maryland or New York or Pennsylvania people in your pool of data. Chances are most law firms I know have people in their databases from all over the country and probably from all over the world. You have to comply with all of those different statutes, and it gets expensive really, really quickly. A fair amount of those statutes require, if you look at the second bullet point here, that you notify the attorney generals of those states. In some cases, it's the Secret Service. In some cases, it's the state police. They have a division. But, you know, not only do you have the breach and have to do a whole bunch of things like getting forensics and doing mailings to the involved people, you've also got to tell the authorities, which is no great joy, and sometimes those authorities turn around and put you through the ringer in terms of what they expect from you. This just gives you a sense of the trend. Look at 04, state with notification laws, 1. You know, and then you work your way up, and you start to get a sense of where we are now. That doesn't even count the federal law. You know, there's the numbers going up, but here we got some federal laws on top of and overlaying the state laws. So it's not one or the other; it's both. And if you're using credit, although probably not so much for law firms, I believe the ABA went to war on this one, but anybody who uses credit, including your clients, probably have a duty under FACTA to have a red flags program to talk about how they police identity theft issues in their environment. So that's one thing that you're going to be asked about if and when you have a breach, or certainly if your client does. And that just kind of kicked into in the last year or two. So that's somewhat new and different, as is HITECH, which came out only in the last 2 years, and that's just more HIPAA if you think about it. But what HITECH really means is if you have data in your databases about individuals and it's health-related, then you have HITECH exposure. And if the minute you have a breach, and this is a really low threshold, under HITECH, and the lawyers in the phone will appreciate this, the threshold is did you allow unauthorized access to data? Well, that doesn't even mean you have to see it was stolen. That just means a bad guy got into your system and swum around for a bit. So that's a pretty low threshold, and you've got to prove it didn't happen. The burden is on you. So what that will do is I'll trigger all kinds of notices that you've got to send to these individuals. And just think in terms of a spreadsheet. If you have a mass tort or a class action, you get a spreadsheet with 5,000 names and pieces of identification on it about medical information. Where does that spreadsheet go after you delete it off your laptop and flip it to an associate? Who knows? And if you lose that laptop, you know that's really gone. So that's the kind of thing you have to think about. What are we talking about in terms of breach costs? These are some. And this is what I do all the time. I get that call, hey, we had what we think was a breach event. Tell me what happened. So I hear what happened. They're almost never entirely right. But it becomes pretty clear that you have to get some kind of independent forensic help to go in and find out, A, is this event even over? Because if you lost the laptop and didn't shut it down, is someone using your remote access? If you had somebody who's a hacker in your system, did they leave back doors that you think you closed but you're not really sure? I will tell you that when you're talking to plaintiffs' counsel, when you're talking to attorneys general or Health and Human Services or Office of Civil Rights, they always want to know if you hired a forensic team because, frankly, they don't trust your team. Your team is the one who let the IT problem happen in the first place, and it doesn't have a lot of credibility. So you're going to want to get yourself a forensic vendor. They're not cheap, but they are generally covered under the policies that are out there. You're also going to have to figure out, after you figure out the facts, what exactly has to be done. What notifications have been triggered? Have any been triggered? Did encryption give you a safe harbor? Are there federal laws, state law, Canadian, Mexican, overseas? If you've got credit cards involved, you've got the payment card industry, and that's a combination of Visa, MasterCard, Discover, and Amex, and they have their own regime, which is somewhat contractually based, but it's quasi-regulatory. You've got to deal with that. When you send out 10,000 or 100,000 letters or even 1,000 or 2 letters telling people that their data has been compromised, you don't want to take all those phone calls that are come flowing into your firm. You want a call center. You need it. You have to have frequently asked questions. Depending on the level of visibility of the breach, you may need PR help. You're probably going to want to offer some type of identity theft monitoring, restoration insurance, the things up on the panel here. And I will also point out that none of those 3 things, the insurance, the monitoring, or the restoration, are required under any statute in the country. So you don't have to do this, but there is an expectation that you will do it. I saw some statistics recently that suggested if you do offer things like monitoring and restoration and oversight, you have some 5 or 6% less likely or I should say 5 or 6 times less likely chances of being sued.
Yep.
So it does create lesser risks for you.
On that point, John, so we know some plaintiff lawyers in this industry because we do different conferences, privacy liability conferences, and they come and they speak. They're of the big belief that that call center is competent and gives victims proper information and very forthright, that you can nip it in the bud and really come away with no claims. But where they get their cases from is they feel the victims were mistreated by the call center or the company who's trying to ignore or brush it under the carpet, and that annoys the victims. And then it's when they hire the plaintiff lawyers.
That's right. The plaintiff lawyers are always out there trolling for the aggravated client, and so you want to try to avoid that. And that whole process I just walked through there in a minute or so requires an attorney, because there are legal decisions being made throughout. There are things that should be cloaked in privilege in terms of conversations that are happening. You can only imagine the PR vendor on the phone with the managing partner and how you want to deal with this or that kind of an issue. You also may have a web presence, and if you do, if you're a big enough firm, or certainly if you have clients who are, they're going to have web presences, and there's going to be blogs out there, and how do you address that? That's separate and apart from notice issues under the law. So there's a lot of different things that happen there. As to the second part of this slide, we're talking about the management piece of this, and again, Mark plays a big role in this with his company, Net Diligence. But if you're not planning on how to deal with a breach, you're not ready for it. If you don't have insurance in place, you're at risk. Most law firms can't afford to have hundreds of thousands of dollars coming into play that weren't on budget. That has a way of damaging profits for the year. So it's something to think about. Massachusetts, and I said earlier, the federal FACTA requires breach planning to be in place in writing. And if you have a breach, chances are you're going to have somebody who was in your data pool who either was from or moved to Massachusetts. I've been on the phone with their attorney general, and they ask for those plans. They say, give me your written information security plan. If you don't have anything to give them, you become a much more interesting target for the AG to make a point. And you really just don't want to be that person. As to the PCI, I talked a little bit about that before. Interesting thing there is, on top of it being the Amex, MasterCard, Visas of the world getting together and creating a standard that is only, well, it's on the edge of unkeepable, because the minute you have a breach, they say you work within the standard. But there, Nevada has created that to be the standard that you have to hit under Nevada law. And that's just typical of the diversity of local laws that you've got to deal with when you're dealing with these kind of problems. HIPAA, any law firm who does any kind of insurance work, defense work, major litigation is going to have HIPAA. And any law firm that has employees, which would be everybody, has HIPAA information, because you've got employees, you've got healthcare forms every year for their insurance that they get. They fill them out. It's about them. It's about their spouse. It's about their kids. So everybody's got HIPAA information, and if you think you don't, that's not the case. So let's talk about the kinds of litigation that we're seeing out there. There are really 3 kinds of litigation. One is a single plaintiff, and that's Mass General is an example of that. Somebody lost 190 records on a subway. Those records never resurfaced, were never misused. They just went away. But they had to report it under HIPAA, and in the end, they were fined $1 million. Who only knows how much it cost to get to the $1 million? But the single plaintiff comes in on that, because separate and apart from being fined by the government for that $1 million, mind you, it's paper that just went missing. It was probably burned that night at the end of the subway, refuse depot. But they were sued by 24 different people out of that 190 for individual lawsuits. Things like pregnancy status, HIV positive tests were in that pool of information. People don't like it when that information gets out there in the public. The fact that it was never ultimately found or misused didn't stop it from being sued, didn't stop huge exposures from happening. So that's a single plaintiff type thing. I'll jump down to the banks here. When you have credit cards in your database, and a lot of people take credit cards, debit cards for different reasons, you may not be exposed to the law firm to FACTA red flags, but you will be exposed to banks when they turn around and say, hey, you lost all this information. There's a cost to that. So you see yourself getting sued. person in your class not alleging fear of future identity theft, but rather alleging actual identity theft. Hey, it happened to me. I was in your breach. I got your letter, and I had identity theft. Well, that person's getting through motion practice to a jury possibly. So that raises up the risk ante, and you don't want to deal with that. By the way, 5% of the country has ID theft anyway. So if you have 10,000, do the math, 5% of 10,000, you've got a certain pool of people in any database loss where you're going to have people who can allege that they had identity theft happen to them. So that's what that means. The next one is the Starbucks, and also in Hannaford. The thing that happened here was, I think it's the 2nd and the 9th Circuits, but don't quote me on that, both said, hey, if you come to us and just allege fear of future identity theft, that's enough. Or that you bought insurance as a result of fear of future identity theft, that's enough. And like anything else, when you're in the business of managing your risk, the closer you get to a jury, the higher the risk, the higher the costs. These are some of the costs you're going to see in litigation. Most of the people on the phone will appreciate these. There's an e-discovery component to this. You've got to get ready. If you get sucked into a lawsuit that's a class action, it's highly unlikely it'll be filed by one firm in one place, more likely to be a multi-district litigation. There's going to be a lot of contract review indemnity issue challenges. There's a lot there that you have to deal with that, the things are not cheap. The assertions are going to be, you have to reimburse us for fraud, we've replaced cards, you've created fear of future harm for 10,000, 100,000, a million people. It's not hard to get some big numbers. This is some of the stuff we talked about before. You're going to get sued in multiple jurisdictions. You're going to have plaintiff's attorneys asserting things like, hey, this class plaintiff already had identity theft, or that class plaintiff is fearing future identity theft, or that class plaintiff bought insurance because of the fear of future identity theft. And all of those matter now depending on the jurisdiction. Time as an element is also an issue. They're saying, hey, you wasted my time. It's just not fair for me to spend an hour or two. Now, the reality is, if I get one of these letters in the mail, I throw it out. But if my parents down in Del Boca Vista with the Seinfelds, if they get it, they're looking at their credit all the time. They're scared. They're watching their 401k shrink, so they can make an allegation that they spend an hour or two a month. Well, times that by minimum wage. FreeCreditReport.com with the bad commercials on TV and the bad music, that's not free. That's 18, 19 bucks a month, as last time I checked, or something in that neighborhood. That's not free. You can get these claims up into the hundreds of thousands of dollars, no problem. And then you have the kicker at the bottom here. When the FTC, including this week, fines companies for these kinds of losses, they put them on 20-year regimes of reporting and auditing. Why? Because when you lose someone's Social Security number or their mother's maiden name or their place of birth tied to their name, that stuff doesn't change. My social's never going to change. It is what it is. So that's not an exposure that I have for 1 year. It's an exposure I have till I'm dead.
In fact, the bottom bullet point there, if you actually Google today, MySpace just had a settlement announced by the FTC, similar to what John's quoting here, ChoicePoint, where now they got to go through 20 years of audits, providing that back to the FTC because they had some kind of privacy breach issue.
Yeah, so dialing it back and you say, hey, 10,000 is not a big number of my database, but if you call it 200 bucks a head between credit monitoring and time wasted, and then you times it by 20 years, it becomes a pretty big number. I think the number is 40 million just out of those calculations. So you get to 40 million pretty quickly, and you get to say, if you're a plaintiff, hey, that's just what the federal government requires. I'm not even being a pig about this. Actuarially, this pool of people might have lived 40 more years. Well, we'll take 20. It's a pretty big multiplier. So what can be done? This is the stuff, and Mark will probably chime in here. I highlighted what I think are the most important things when I get a breach call. That is, do I have somebody on the phone with me who has real authority from that company to make decisions? Because there are SIRs to manage deductibles. There are all kinds of PR issues. There are outreach issues to authorities. It's all kinds of complicated issues. And if you don't have someone designated ahead of time to be in charge of this, you are not ready. The next one I have highlighted is the assessment. There's a million reasons to get assessed. It gives you a roadmap of what you need to fix. It gives you a better deal when you go out and get insurance. It also gives me a tool when I'm dealing with regulators and plaintiffs' bar to deal with and say, look, these guys were ahead of it. They assessed it. Yeah, there was a breach, but it gives me something to hang my hat on in terms of the defense and insure it. Like I said before, The first thing out of my mouth when I get a call is, do you have coverage? And the minute I know that it's a yes, I feel better for that company. So those are my thoughts in terms of what can be done. I don't know if you had anything extra there, Mark.
No, I mean, I think that summarized it, pretty good, John. Easier said than done was the final bullet there. Again, we talked about a lot of things here. There's so many nuances and variables, though, everybody. We see companies with 50 dedicated security people, $50 million budgets, and they still get hit each year. There's just too many things happening out there. And to my earlier slide, there's too many points of failure. Data sharing between your outsourced providers, your contractors who come into your firm, your IT folks who go from one job to the next. A lot of things just happen and mistakes are made.
So the other thing I wanted to talk about, since we have an extra 30 seconds or so, is mobile devices. Mobile devices, everybody's got them. iPhones, you've got iPads, you name it, BlackBerries. A lot of those devices have data on them, and almost all of them grant some kind of access into bigger databases. Some of them can be wiped quickly, but the fact that you can wipe an iPad quickly is helpful. But if the person loses it on Thursday and you don't hear about it till the next Friday, that's not nearly as helpful. And if that's somebody in your firm who's in a partner role or a management role, theoretically, under a lot of analysis of the law that you have to deal with, access was granted through that device all the way through to your biggest systems. Last time I checked an iPad, most of them have a 4-digit all-numeric password. Not exactly the most secure thing in the world, and an average hacker can get through that in about 10 seconds. So all the mobile devices that you've got out there, you've got to factor into the controls you have, the risks you have, and certainly the lawyers I know have a ton of them. So
I guess with that,
we are done. We were told 40 minutes. I think we hit it about 10 seconds.
we're open to questions.
Thanks very much, Mark and John. And I think on the next slide, if people do have questions, we are at our time limit, but we'd like to encourage you to reach out to Lawyer Cover, to Net Diligence, to Nelson, Levine, DeLuca, and Horst. All the contact information is there on your screen. You can also visit their websites, lawyercover.com, eriskHub.com, or nldhlaw.com. And again, we thank you for being here with us today for this important information. Of course, we thank Lawyer Cover, Net Diligence, and Nelson, Levine, DeLuca, and Horst for presenting today. And we look forward to seeing all of you at a future Lawyer Cover sponsored webinar very soon. And with that, we wish all of you a great afternoon.